Good day to you. I am Wong Yinson, and today Puteri, Eva, Nurul Ain and I are going to talk about copyrights, more specifically performance copyright. We know that copyright refers to the legal right of the owner of intellectual property. In simpler terms, copyright is the right to copy, which means that the original creators of the intellectual products and the people given authorization to are the only people with the exclusive right to reproduce the work. However, unlike copyright laws which have existed for quite some time, the law dealing with the protection of performers is quite recent. In Malaysian context, performance protection was only added into the Copyright Act 1987 in the year 2000 amendments. So, why did this amendment come so late? And how different are performers from other intellectual property creators? Well, one of the justifications for this is that back in the days, there is an absence of recording technology, which means that the performance itself could not be reproduced. If you were interested in the performance, you would have to attend the performance physically to watch it. As technology advances, there is a crucial need to protect the rights of the performers, and hence the amendments. However, it is worth noting that oftentimes a performance involves other copywriters as well. For example, a traditional wayang kulit, the Malay puppet show, might be authorized to use another copywriter's music to play the show. Say, if someone illegally recorded the puppet show, the person will be infringing two different copyrights at the same time, which is the music creator's copyrights and the puppet master's copyright. The term performer and performance can be found interpreted under Section 3 of the Copyright Act 1987, which includes dramatic work, musical work, recitation of literary work, dance and circus, and etc. These are the performances that are protected under the Act. Now that we know who the performers and what performances are, we will now discuss the current significance and effectiveness of performers protecting their copyright. The utmost significance of performers' copyright protection is to safeguard the performer's economic and moral rights. For starters, it is important to understand that most performances are usually live, and once recorded, it is regarded as fixation defined under Section 3. Once the performance is fixated, it is subjected to Section 16A of the Copyright Act 1987. Under this section, it lists out the exclusive right granted to a performer, and other people need prior authorization from the performer before using the performance. One of these economic rights that is protected is the right to reproduce under Section 16A sub 1 sub c. This right for the performers is significant as it controls the reproduction of his performance. Prior to 2012 amendment, this act only protected the reproduction of fixed performances. However, now it also prohibits the reproduction of the live performance itself, which means that recording during a performance is prohibited if the recording was done for commercial use without authorization. This section is significant as to protect the performer's economic right to make copies of their performance. If this right is not protected, anyone could have easily made recordings and copied and subsequently distributed them online. If this right was not safeguarded, in this modern age with the advancement of online ad revenues, people who had no contribution to the creation of the performance could have easily made ad revenues from online videos or music sharing platforms. For the subsequent parts, I will leave it to my learned friends. Thank you.
Further, I will discuss about the right of commercial rental which is provided in Section 16A subsection 1 sub e. It allows the performer to control the commercial rental to the public of copies of his performance, regardless of the ownership of the copies rented. In the context of copyright, rent means the action of renting something in return for payment. The original recording or the copy that is rented is to be written for direct or indirect economic or commercial advantage. The rental must be in commercial nature, which means that some form of economic or commercial advantage involves profit. This commercial rental right enables the performer to gain profit from rental activities, since the nature of the activities is commercial purposes. For example, if a song is being used for an advertisement, The singer has the right to claim for the reward since his song is being used for commercial purposes. This right is significant to strengthen the performer's income and effective since it enables the performer to derive reward from his work. Next is right of distribution. The performer's right of distribution is provided in section 16A subsection 1 sub D. This distribution right allows performer to control the first distribution to the public. The provision applies equally to the original fixation and to their copies. However, the performer does not have any right to control subsequent distribution of the copies as subject to the rental right in section 16A subsection 1 sub A, which the exhaustion of right doctrine takes place. Thus, if a performer puts into circulation copies of the fixation, he cannot control its subsequent distribution or sale. Distribution right gives the performer the right to bring an infringement action against anyone who distributes a copy of his work to the public for the first time without obtaining any prior consent from him. Once the copy has been put into public circulation by the performer with consent, he does not have any right to control how those copies are dealt with, subject to the commercial rental right in section 13 subsection 1 sub F. However, this is not so. The performer's rights are actually not just limited to the first distribution, but also to the subsequent distribution as well, as we can see in the case of Sheikh Abdullah bin Ahmad against Universal Music. The court in this case held the performer's right under section 16A subsection 1 was not only limited to live performances before an audience but also included studio recording. Neither was it limited to the first distribution of the recording, but also to subsequent distribution as well. Even if the performer has been paid for the reproduction by virtue of section 16B subsection 3A of the Act, the performer are still capable to claim for equitable remuneration, which could be applied to the Copyright Tribunal to determine the amount payable as equitable remuneration by virtue of section 28. The court in Performance Right and Interest Society of Malaysia Berhad against Misat Broadcast also suggested the performers to seek remedy to Copyright Tribunal since the Act provides such right. In short, although there is limitation to the performer right once exhaustion of right takes place, equitable remuneration is still available for the performer. It is interesting to note that although the performer ceases to have the exclusive right to control the act once he has given consent, the performer may still claim for the equitable remuneration pursuant to section 16B, subsection 3B sub A. But also to be noted that a performer's right to equitable remuneration only applies if the fixation is in the form of sound recording, but not when a fixation takes a form of audiovisual recording.
The last set of economic rights discussed would be the rights to performance in public and the rights to communicate to the public. It may be significant to first assess the term public under both rights, as this term has shifted in position to attempt to shut out loopholes. In the American case of WNet 13 against Arrow Incorporated, the initial position was that on-demand transmissions delivered to subscribers on a one-to-one basis could not be considered public. This decision was reversed in 2014. It was determined that the subscribers would still constitute as public.
As for the Malaysian position, the amendment in 2012 under Section 16B, Copyrights Act 1987, supports this contention of public, as it is outlined under commercial purpose as being made available to the public, where members of public could access them with time and place individually chosen by them.
This definition effectively prevents the loopholes, often just to avoid the payment of licensing, as anyone can be considered the members of public. As Recording Performers Malaysia Berhad is responsible to collect the licensing on behalf of their members, which are often performers, it is also strengthening the protection of the performers to be able to earn royalties. However, as this will be later assessed, the performers may not be as well protected due to other factors. Thus, the rights to a performance in public as an economic right should then be discussed. The significance is originally to ensure that there is compensation for performers in a public performance, as can be seen with licensing bodies. This entire right has numerous limitations. The term performance is defined under Section 3, Copyrights Act 1987, to refer to live performances. This was reiterated in Prism Berhad against Misat, where the judge appears to confirm that a performer's right is limited to live performances only, and the facts shown could not concern a performer's right. Thus, licensing fees could only be claimed where cases were copyright following Section 3, Copyright Act 1987. The rights to a performance in public on sound recordings, for example, could not qualify for licensing, but rather equitable remuneration as under Section 16b, subsection 1, Copyright Act 1987. Nonetheless, this only proves two issues: that only sound recordings and live performances would be protected as a performer under the right of public performances. There seems to be insufficient room for interpretation, partly because there is no specific provision for the rights to a performance in public, especially under Section 16, subsection 1, Copyright Act 1987. The lack of provision for this right thus cannot utilize cases like Sher against Universal Music, as mentioned by Puteri, in a broad interpretation of performance. Misat may be the only deciding case for this specific right. The small advantage of a performer's rights is if they may then obtain a licensing fee, which then may be found under Public Performance Malaysia against Prism Berhad, where there are evidently two licensing bodies to collect royalties on behalf of the performers. They may gain from the added exposure of being members of both of these bodies. Nonetheless, the right to publicly perform evidently does not seem to be as effective in application, as courts evidently view this specific right in a very strict manner. On the other hand, the economic right of a performer in its communication to the public is listed under Section 16a, subsection 1a, Copyrights Act 1987, where a performer would have significantly exclusive rights on the communication to the public of a performance unless that communication is in itself a live broadcast performance. The UK case of ITV Broadcasting Limited against TV Catch-Up Limited may be utilized in its interpretation of the term communication, where online transmission would certainly be considered to be a part of the term communication, and thus it is to be interpreted broadly. However, compensation may still be an issue. Although the House Breeze Laws of Malaysia of Intellectual Property cited Misat as a determining case, one can attempt to use Sheikh against Universal Music's interpretation of Section 16a, subsection 1, on its definition of performance. It was acknowledged, however, that this prejudice towards performers in this aspect should be avoided through the performers entering into a favorable agreement, which would ensure a better form of compensation. Performers appear to require some due diligence in realizing that they may not be compensated well, in contrast to those like authors or songwriters, and this concern must be reflected in their contract. It appears that for both of the economic rights to performance in public and rights to communicate to the public remain prejudiced, despite its significance to be able to compensate and retain control of behalf of the performers. To be able to retain these rights, performers must assess their contracts thoroughly, because both remuneration and licensing fees may be hard to guarantee on this aspect.
Article 6 BIS of the Berne Convention for the Protection of Literary and Artistic Works of 1886 requires its member states to provide protection for two types of moral rights: the right to paternity and the right to integrity. Therefore, the law grants moral rights to performers to protect the integrity of their reputation. Both of these rights last the duration of the copyright in work and ceases once it expires as well. However, even after death, moral rights can still be exercised by a personal representative. They also apply to all categories of copyright under the Act, whether the works are the author's or are entrepreneurial. The significance of the right of paternity is that it is a fundamental moral right, because it is through this that the public gets to know who the author is, and the absence of it would render the second right related to distortion and putting the author in a disadvantaged light, devoid of meaning. Section 25, subsection 2 lays down the aspects of this right, stating that the author must be identified during the presentation of the work, and that the work is not limited to public presentations either, and it also applies to adaptations of the work in question. So in the case of Sheikh Ahmad Jamal and Datuk Bandar Kuala Lumpur, a sculpture was modified so much so that there was nothing left to identify the plaintiff as the author of the sculpture. So consequently, the court held that the Defendants Act had infringed upon the moral right of the plaintiff to be identified as the author of the work, therefore illustrating the effectiveness the Act provides in protecting the author, or in this case, the sculpture. Section 25, subsection 2, subsection B, however, prevents anyone without the consent of the author to distort, mutilate, or modify a work if to do so would significantly alter the work and reasonably be regarded as adversely affecting the author's honor or reputation. Therefore, it simply pertains to the right to object to the derogatory treatment of the work. This relies heavily on the belief that it embodies the author's personality and should therefore be protected. The moral right doctrine is significant as it controls reputational externalities to the potential benefit of the performer. Without it, it would not be possible for a performer to retain continuing interest in their work after its sale. This right of integrity therefore enables these performers to take legal action against the current owner when needed, such as in the aforementioned case of Sheikh Ahmad Jamal, where the significant alteration was said to destroy the serenity intended by the plaintiff, and as such was regarded as affecting the plaintiff's honor and reputation. And this was aided by the witnesses that claimed that it was in fact a willful defilement that destroyed the originality of the work. Despite the arguments brought forward that it was mandatory restorative work, Section 25, subsection 2 still continues to apply, ensuring that restorative work does not affect the artist's honor. The significance relies on the incentive being derivative of art commonly involving reputational externalities, which does afford the artist and others a strong interest in protecting the integrity of their work. A performer may have their own personal interest of preventing the reputation of their work from being depreciated. It actually also concerns public interest as well, as great works of art tend to become hot topics or important elements in a community's culture, and in turn, other works of art may also be created in response to them. As they become icons to society, the alteration would be costly to the community as well. Moreover, the growth of revenue following the increase in the consumption of media and arts in recent years gives more incentive to protect performers alike, as they would lose their ability to attract demand for their services if their reputation were affected. Therefore, the significance of protecting performers' rights through moral rights ties into the public good, and the laws in place contained within the Copyright Act prove to be effective in upholding just that, as the damages serve as a deterrent to society as a whole. Although not economic, it indirectly controls how a piece of work can be commercially exploited as well.
Despite all the rights conferred to the performers, there are still circumstances that amounts to a defense for recordings during a performance. These circumstances are listed under Section 16A sub 3 of Copyright Act 1987 and includes private and domestic use, scientific research, reporting of news, and etc. However, these do not seem to undermine the effectiveness of the protection of the performer's right, as long as they do not record it for commercial use. In conclusion, it can be said that the main significance of protecting a performer's right is to safeguard the performer's economic right and moral right. The economic right being to ensure that the performer has the control and his say on his performance and who has authority to use it. Moral rights are significant as it dignifies the performers and the right for them to be recognized as the author. As observed, there are some amendments done in the past few years, and these amendments really improve the effectiveness since it is protecting the performers better by making it more stringent and provides the act for more wide interpretation which mostly favors the performers. The performers are also able to claim for remuneration in event of infringement of their right. However, it cannot be doubted that there is a lack of case authorities to help interpret the law in this area to be more sophisticated. As such, we wish that the performers may be able to take more stringent actions against unlawful copiers as per the rights conferred to them by the Copyright Act 1987, and may this area of law be more well interpreted by the courts in the future. That's all from me, Yinson, Puteri, Eva and I. Thank you for watching.